to start with my presentation, as earlier mentioned, the title is Challenges and Barriers on Granting Financial Compensation. I will try to stick with the time and not to repeat what the professor mentioned earlier, but just a quick review of the, let's say, European framework, because it has already been analyzed. Yes, of course, sorry. Okay, going back to the instruments on the European Union level and also at an international level, it has been quite an evolution, if I might say so, because taking into account the number of instruments that have been adopted in order to protect the victims of human trafficking and in general the victims of crime, starting with the declaration of the UNGA, the General Assembly of the United Nations, and the European Convention on the Compensation of Victims of Violent Crimes, and obviously going further to the directives and framework which has been established at the level of the European Union. But as I was saying, I will not enter again into the details since they have already been presented by our colleague. But I will mention, though, that in 2017, the Commission issued a communication also addressing the actions that need to be taken in order to address the trafficking in human beings, also including the issue of compensation in relation with the victim of crimes. Also, I have read and I found extremely interesting the report of Joël Miquet, which was finalized in 2019. She actually has been appointed a special advisor by the President Juncker in order to address particularly this issue related to compensation and reparation of the damages that the victim of crimes suffer. And in her report, she presents obviously it's a double structure. So she presents first the problems she has managed to identify at the level of the states members to the European Union. And she proposes 41 recommendations on how to improve the protection of these rights, and also in order to even improve the framework at the level of the European Union. I'm going to present now a bit of the, let's say, the issues that were identified by the special rapporteur Joël Miquet, and also compared to the issues that we managed to find at the the Romanian level. So, of course, I would say that limited funding still seems to be the main problem nowadays and also in the past, because usually when we want compensation, someone has to pay, obviously. So in order to pay, we have to have also funds. And here, but I will address this issue later on by referring obviously to the Romanian legislation and Romanian issues. It's usually either the state who is going to pay or the perpetrator, depending on the victim's choice, or of course on the framework available at national level of each state. Also, Another problem would be that the information, and this is also in Romania a problem, the information is not always accessible for victims of crime. uh, um, it's usually you can find it on the internet, but we have to think and take into account that not all victims have access to internet, so maybe they come from a poor environment. Also, supposing that they would have um, access to the internet, the format and the language in which the information is available, it's also quite not so appropriate, taking into account that um, usually the main language is English, or in our case Romanian. So if the victims, because we are talking here about the um meaning the title of the seminar is about the third country nationals, they usually are not supposed to uh, know and understand Romanian, or not even English. So, supposedly, if we'd have an Albanian or Greek, if you were to take a look at the victims of human trafficking statistics available at the European Commission level, um, they might not understand the language. So the sharing of information is also a problem identified by the report of Joel, and also identified at the Romanian level. Um, Going further, also there is a problem again related to the uh, money, but this time related to the amount paid. And there has been a national European national group initiative that has been made by the some of the states at European level, um, in order to address the problem of compensation and also other rights of victims that fall um, actually victims of crimes at the European level, and it is called the European Network of Victims' Rights. You can even check the link. It is that is available on the PowerPoint, and you can find there a lot of useful information. Also, some inquiries made by this group regarding the amount of the compensation, the amount of compensation paid by different EU member states. And apparently there is a huge difference in the amount paid to this category. So it can vary from thousands of euros, in our case in Romania, even 100 euros, and it can go much further depending on the state and its legislation. And I must say here that in Romania, we don't have, like in some other countries, and again, you can check the portal of the ENVR, we don't have a fixed amount of the um, money that are going to be paid as a compensation. So it is going to be established on a case by case basis. And usually it's established by the judge in court. And I must say it's quite law. Okay. Also, we have here the problem of what do we compensate? What exactly are the components of the compensation? And I refer here, of course, to the notion of state compensation, not from the perpetrator, so not the option of getting compensation from the perpetrator. So there is also a great problem with what and who is compensated, because the type of damages that are available for state compensation and people, the victims that qualify for state compensation also varies from country to country. So the legislation is quite different. And also the DNVR inquiry shows that some member states compensate medical costs and loss of earning also during the medical treatment. Some states also compensate psychological damage and even long-term individual needs, such as psychotherapy, adoption, or houses. And in my view, these are extremely important for the victims of human trafficking because it is not enough, in my opinion, just to pay the loss of earning or the medical costs and to forget about the fact that that person is traumatized and it would need long-term psychotherapy and even housing in order to be able to recover and get a better life. So um, uh, it is a problem because there are countries that do not offer full support related to the compensation, and I would say Romania, it's among them. Now going further with other obstacles, and of course we get to the court part. So usually in order to seek compensation, um, even if we talk from on behalf of the offender, of the perpetrator, or on behalf of the state, depending on the choice of the victim, uh, they have to submit legal forms and make an application to the court. And of course, the procedure is different depending on the jurisdiction involved. And again, this is complicated because there are a lot of legal technicalities, and usually victims are not familiar with these technicalities. They do not know the legislation. They do not know they have the right to legal assistance. So they get lost among these technicalities. Sometimes what is the most peculiar thing is that they don't even know they are entitled to seek compensation and what is the procedure to get there and obtain it. And here we must take into account that usually the most vulnerable victims are children, undocumented migrants that get trafficked. Basically, this word challenges I managed to identify both at European level and also at a national level in Romania. And I would like now to move on to the legal provisions in our country that address the issue of cross-border compensation. I'm going to focus on the law 211 from 2014 that of course has been amended according to the directives. And I would like to mention here that we have to take into account two situations that are provided by the law 211. So, according to chapter 5, we have two options. The first one is uh, when a person seeks for help in the situation in which the crime has been committed on the territory of Romania. And it's uh, hmm, actually developed in the chapter 5 of the law and all the details, but since also time is pressuring me, I'm not going to enter in all the details. But the first option is when the offense was committed on the territory of Romania and the victim is a Romanian citizen, foreign citizens, or stateless person, but legally residing in Romania or present on the territory of Romania at the time of the offense, when the offense was committed. So we are talking here about the situation when the offense is committed on the territory of Romania. Uh, the second situation I was mentioning is also provided by chapter 5, 5.1, if I might say so, because it has been amended, and address especially also the cross-border situation in which a person um, asks for compensation, but the crime was committed um, on another on the territory um, of another state of the European Union, apart from the one he resides. So in this case, um, the crime was not committed in Romania, but we are talking again about Romanian citizens, stateless person, or foreigner legally residing in Romania, but the crime was committed on the territory of another state. Um, in both situations, the categories of the victims that get to be compensated according to Article 21 of the law are the victims of attempted murder, first degree murder, victims of bodily harm, victims of a crime committed with intent that resulted in bodily harm, victims of rape, sexual intercourse with a juvenile, and sexual assault, victims of human trafficking, of terrorism, and other deliberate offenses. And also, apart from the victims, we compensate the spouse, children, and dependents of the person deceased as a result of the crimes mentioned above. So this is common for both types of compensation procedures. So also in the case the offense was committed on the territory of Romania, and in the case the offense was committed outside the territory of Romania. Coming back to the situation in which the victim of the international crime um, is a Romanian citizen, stateless person, or a foreigner legally residing in Romania, but the crime was not committed on our territory. We have here, and I am talking about the procedure. We have here main actors, if I might say so. We have the solicited state and the soliciting or requesting state. Um, uh, in our situation, we have the Ministry of Justice, where the person can submit a request for obtaining financial compensation, um, and also file all the supporting documents. Within a maximum of 5 working days from the receipt of these documents, the Ministry of Justice will transmit the request and the supporting documents to the decision-making authority of the state on whose territory the crime was committed. Also, the Ministry of Justice will provide the necessary support if the decision-making authority of the state granting compensation request direct hearing by video conferences, or telephone, um, and all other procedures that are necessary in order to find the relevant information so that the compensation can be granted. So we are talking here about the close cooperation between the solicited authority and the requesting authority. Um, Also, in our case, because of course, it varies from country to country, the authority regarding the claims for financial compensation is the Commission for Granting Financial Compensation to the Victims, which is constituted within the Bucharest Tribunal. And it is usually composed of at least 3 judges. The Commission um, receives the request for financial compensation directly from the applicant, of course, through the assistance authority of the state on whose territory the applicant resides. And then the Commission will send to the authority responsible of assistance in the requesting state, as well to the applicant, a confirmation of receipt of the request within 5 working days, and also the name of the contact person within the Commission in Romania. And usually, but in our case, this does not happen very often, a deadline for resolving the request for financial compensation when possible. Um, Also, I would add here that the 5 working days um, receipt of request does not work that smooth all the times, taking into account the post-working services in Romania. Of course, the decision resolving the request for financial compensation will be communicated to the applicant and to the assistance authority of the requesting state in the form established by the European Commission decision. And I must say here that there are standard forms of application, and they are annexed to the Council directive from 2004 in Annex 3. So every state will use and should use the standard forms provided by the Council directive. I think the key issue here is the cooperation between the two main actors, the solicited state and the soliciting or requesting state, in order to provide a quick procedure and not to emphasize its lengthiness, which is the case most of the times. And also, if I were to come back to the Joël Miquet report, I would say that we still have a lot of problems related to the compensation challenges also in Romania, but at European level. And I would like to stress here that, for example, it is up to the judges to decide, like I was stating at the beginning, to decide the amount of money that are going to be paid as compensation. And from my experience, I have seen cases that in first instance, the court has granted a certain sum based on its subjective consideration and appreciation of the circumstances of the case, because I was mentioning that the amount is established by the judge on a case-by-case basis. And then if the decision has been appealed, the judge of appeal has granted another amount, which is quite different from the initial one granted by the first judge. Well, I hope I have managed to respect the time for my speech, and I thank you for the attention, and if you have any questions. Thank you.